Karen Reed's motion to dismiss has been argued. What next?
The judge had nothing to say, but now the ball is in her court.
Was the motion to dismiss just a waste of time? Karen Reed's motion to dismiss happened on August 9th, 2024, but Judge Bev did not seem amused. I'm Lainey Law.
And I'm Attorney Andrew Myers.
And today joining us, we have Attorney Yoli. How are we doing today, Yoli?
I'm fine, thank you, and thanks for having me again.
So if you haven't checked out our live stream, be sure to check that out. We reacted live to the motion to dismiss. And we heard a lot of talking from the defense, some talking from the prosecution, and pretty much nothing from the judge. Is that unusual? Wouldn't you think that she'd have some feedback, some questions?
Well, I thought it was unusual. Yoli, what about you?
I thought it's highly unusual, especially for a motion like this. Generally the judge will ask questions. How do you reconcile this with that? Or, she just seemed to be listening, and her demeanor was just flat.
Yeah, I've argued many motions and applications and trials and pretrials in Superior Court in Massachusetts. I've been practicing in Massachusetts for 30 years. And, specifically with motions to dismiss, motions for summary judgment, motions to suppress, all those kinds of motions. And it is expected that a judge is going to interrupt you. They're usually pretty polite about it, but they have clerks that read your stuff in advance. When I go into court, I know that 99 times out of 100, the court clerk has read it, or I should say the legal assistant to the judge. They have clerks, they have assistants, they have interns. Mm-hmm. By the way, our intern Red isn't here this week. She's off at a seminar. But anyhow, so they have these people that write summaries for them. Yeah. They write bullet points for them. And so I fully expect that when I go into a superior court, specifically Massachusetts, I'm going to get questions. Now, the judges are usually pretty polite about it. They'll wait until the end of the sentence. They'll wait until the end of the paragraph. They'll wait until the end of the thought most of the time.
Before they say, Attorney Myers, excuse me.
But that's exactly it. And that's expected when you go into court. That's why, before you go in, you prepare. You read the cases. All of these motions cited a lot of cases. But, for example, the ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of the power of the American people. Then it gives a cite and moves on. But when you go in front of a judge, they can ask you, Attorney Medina, what else does that case say? What are the my least favorite question that you get? Well, what are the facts of that case? You know what I mean? Did you ever get that one? You cite.
I have, and luckily I know the facts.
Yeah, you and me both. That's my point. You prepared for it. Yeah,
because the annotations that you get in a statute, like there's a statute, and then they give you cases that have interpreted that statute.
Right. And
sometimes people just look at those cases and they just look at the holding of the case. What the case stands for, and they don't look at all the facts in which it occurred. So sometimes the judges will ask, what are the facts of the case? Because the judge may know the facts are a little different than your case. Even though the holding was the same, it stood for the proposition of such and such, but the facts might be different. And so, I've had that question asked about what are the facts in that case, Ms. Medina?
And not only that, Attorney Medina, also, that's the majority opinion. What did the minority opinion say?
I've never had that.
I had that.
The dissenting opinion? No, I've never had that.
Yeah, I've had that question. And, my only point is that, you go into a superior court hearing, and I'm not talking about appellate. That's the whole nature of the beast in appellate court. But in superior court in Massachusetts, I've going in and try to be as prepared as I can. If I'm up against you, Yoli, I read your brief. I read your cases. I have the cases all downloaded, and I'm right because you're right. People, it's dangerous to just cite the case holding because before they get to the holding, as you know, there are facts. There's an issue. There are rules, and then there's a conclusion, and you can't just base everything. So that was kind of surprising to me. The court TV camera person panned over to the judge only a couple of times, and it's hard to tell. It's really,
Yeah.
I wouldn't want to play poker against her because she really couldn't.
She just had but she did nod when the defense did their rebuttals. She nodded a couple of times. I did see that. So you never know. She might surprise us, but I don't think so. I think too because the jury, this is a controversial case, and the jury was already released, and there's no telling what happened after that. Did somebody encourage these people to call? How do you know?
Well, according to Juror E, I found this kind of interesting. According to Juror E, this was filed on July 18th, a couple of weeks after the trial, and what Juror E said was that we were riding back on the bus, and nobody really even asked us. And we felt, on the bus as we were going from the courtroom to our car. I'm looking for the exact quote, that we felt that nobody had really asked us, and we just wanted to be certain and tell people, we did acquit her on counts 1 and 3. Count 1 being the major case that could land her behind bars for many, many, many years, second degree. So that's kind of the genesis of the whole thing. They, if we're to believe what we read anyhow, that they were riding back in the bus, and they're all looking at each other going, what just happened?
Yeah, and it's almost like afterthought, right? They had an afterthought because it happened so fast,
It did. It happened awful fast, and
she's not going to admit that. I mean, she's not going to say, "Well, I just shut it down. I just did it fast, and maybe I needed to have done."
Yeah. So, I guess what's next is, I think most observers who watched the trial would acknowledge that the judge is very likely going to side with the Commonwealth, because the Commonwealth said there's no verdict. The only verdict, the jurors can say whatever they want on the bus or elsewhere or in affidavits, but the only verdict is something that's read out loud by the foreman in court, and that didn't happen here.
On the record, yeah.
On the record, thank you. And
on the record during the proceeding. So
right.
Anything that is outside of the proceeding, like the affidavits, I think she has discretion, but I don't think she's not gonna, especially since those jurors contacted the defense first. Now I heard somewhere that these same jurors contacted the prosecutor.
Yes, Adam Lally filed just on August 1st. Adam Lally filed what he called Commonwealth's post-trial notice of disclosure. A notice of disclosure is what he called it, and he, in that notice of disclosure, said that similarly, the Commonwealth received emails from 3 individuals who identified themselves as jurors. These individuals indicated they wished to speak anonymously. On July 16, 2024, the Commonwealth responded to the emails by stating that the Commonwealth would welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiry. See, he's putting himself above everybody else. But yet, Yoli, you're right. He says here that Adam Lally received another unsolicited voicemail on his office's phone line from the same individual who stated he can confirm unanimous charges 1 and 3 as not guilty. But as interestingly, as of the last vote, 9-3 guilty on the manslaughter charge. So
did the jurors contact him at the same time that they contacted the prosecutor?
Okay, to answer your question, Adam Lally did give dates. Sunday, July 21st, ADA Adam Lally received an unsolicited voicemail. Then similarly, the Commonwealth received emails from 3 individuals. One of them was Friday, July 26th. So they weren't necessarily simultaneous. I think they came afterwards because, as you can probably imagine, there was a lot of publicity about this, not just in the YouTubeosphere, but this has been front page headline news. It's been in all the TV stations. It's been on the radio stations. I'm a child of the media. My underground degree, my underground degree, my undergraduate degree before I went to law school was in mass media. And I've known a lot of people in the media. I worked in the media for 10 years before I went to law school. So I keep an eye on it. I keep an eye on the media. And it was even the morning of the motion to dismiss, even in the New Hampshire and Rhode Island TV stations, it was there's been a lot of publicity. So I'm sure the jurors heard what was going on. And so they, took it upon themselves to, contact both defense and
Very strange.
so we have 5 jurors, A, B, C, D, and E, and I'm just wondering, what about the other 7?
Yeah, and what's the judge going to do now? I know what she called impounded the jurors' names.
Yeah,
is she going to keep them impounded forever? Like keep them secret?
my guess is that she will, because one of the jurors who identified herself as Jane Doe had said that she was in fear.
Now, she got her own attorney, right? And filed something.
Now, when we reported that in a previous episode, I got some not very nice comments down below. Please comment. Let us know. Let us know what we're saying that's wrong. One of the things was that the juror said that as they were deliberating, they could hear chants outside.
Mm-hmm.
And I got comments, no, they couldn't hear the chants because the crowd was 200 feet away. Well, I'm thinking 200 feet isn't that far. It's 2/3 of the length of a football field.
Well, I do want to say also during that video, or during the the motion to dismiss, I noticed at one point you could hear a car horn.
Oh yeah, you could hear the car horn better than you could hear the people speaking.
Yes, good point. Yeah.
Seriously, yeah. And it wasn't like we were saying that there was chants out there. It was what the affidavit said that they could hear chants. It wasn't like we weren't saying, oh, you could hear chants out there. No, it was what was written. So,
but we're linked into all that. A lot of people see us as the establishment.
We are the arbiters.
But yeah, so there were some other comments that were made by that juror. They feared they had fears, and so they asked to please be sequestered, and so the judge impounded is the correct word. The judge impounded the list, and so I don't know if I was the judge, I would kind of want to impound. Jurors are free, as 5 of these jurors did. They can contact whoever they want. And we've seen that in other cases. I mean, within days of the verdict in the Murdoch case, 3 of the jurors were on Good Morning America and making the circuit of all the national news. So they are free if they want to reach out to any media or write a book.
I know that in trials that I've had, we've actually gone up to jurors and asked them if they wanted to talk.
Yeah.
I don't know. I guess it's different. It's different if there's a mistrial.
I don't think it's any different. It's just that it's their option, as well it should be. This has been a high-profile case with a lot of horrible, hard feelings.
But I guess that's right after the trial.
There were reports of bleach being thrown on people's yards.
Oh my God!
So why this case is so controversial, I think, is because the law enforcement that are involved are in big trouble.
Yeah.
That's what it seems like. Otherwise, I don't know why there would be such a big this controversy.
Mhm.
Well, it's a little town, Canton. You got to say it correctly. It's spelled Canton, but they pronounce it Canton. And it's a small town. It's divided the town. It's not a good thing that, people are so divided as this. And people on the outside of the establishment just have this horrible feeling that, the good old boys and girls network is in control here. And the good old boys network, did something extremely unseemly. And part of it, I'm going to switch gears a little bit. Part of it is that the original charge was this drunk driving / having a bodily injury accident while driving drunk. And that was, in manslaughter. Those were the original charges. And that's when Karen Reed hired David Yannetti, good lawyer, good defense attorney in Boston. But then and it was over in the Massachusetts District Court, which, as you know, is the lower level court. Then at some point, the Commonwealth, Michael Morrissey, the DA in Norfolk County, decided to take it to the grand jury. So they amped up the charges from the manslaughter charge to second-degree murder. So now Karen Reed is going nuts. She's going absolutely nuts.
Mhm.
She can't sleep. She's staying up late. She's on her laptop. She searches around. She finds Alan Jackson, who is an extremely well-known, popular attorney in California, your neck of the woods. He's had some really high-profile actors, actresses, sports figures as clients. He's well-known. He's got a good...
Alan Spector, or he represented that Spector guy?
Yeah, Phil Spector.
Phil Spector, yeah.
And so she freaked out, and as well, I can understand her freaking out. But just the fact that they took what was one case and amped it up to something else, and now they bring in the big guns, and now the media is, just playing it up as high as they can play it up. That's partly what's to be answering your question. How did this get out of control like this? And so now Boston Magazine, I'm sure you have something like that out there. It's like a feature, newsy people kind of a magazine. Mm-hmm. It's one of these slick magazines that you can buy on the newsstand. I think some people like me still read these magazines, although you can get it online. They wrote an 18-page article about this case. So we're all scratching our heads, and they went pretty deeply into how the town was divided. So I think that amped it up. And there were just a lot of head scratchers. For example, one of the TV stations early on in Boston, and this was confirmed, I heard this live on the radio last night. One of the Boston TV stations actually reported that there was video of Karen Reed backing into John O'Keefe. Well, that turned out not to be true.
Yeah.
And if you Google it, which you can, it was aired on February 2nd that year. Now there's like in italics in print. Well, there was a typographical error or some kind of an error, but they never came on the air and retracted it. So now, these TV people come on, here we are, here's the news, there's video of her backing into the guy. But there was never really a full-on retraction, just this kind of halfway little thing online. So, there've been a lot of things like that in the media reporting on this case. And I've said it before, but I will explain it again. When you're in those TV jobs, you rely on your sources. And nobody really wanted to cross their sources. And so the law enforcement was heavily favored in the reporting of this. I don't care. I'm an attorney and a YouTuber, and there's a million. I make no airs about it. None at all. There's a million of us out here. In fact, I almost didn't even do the YouTube because I figured there's too much competition, and I see that every day. But I don't really care. But the people that are in the Boston media, they want to make it to Anchor. They want to make it out of Boston into New York and the networks. And so they have to rely on their sources. And they really heavily favored the law enforcement all the way along. And, there was this guy, Turtle Boy, got to give him credit, that he was saying, no, that's all wrong. What you're hearing is wrong. And so the establishment really pushed back hard. And the harder they pushed back against him, the harder he pushed back. And, that's why it's become a pretty highly significant case. I'd like to ask you a question, Yoli. I mean, you only got involved in this because, you and I have become acquainted, associated, I'd like to say friends over YouTube. You never really heard of this case until we started doing these episodes. Is this case being covered in the media out there in California or not really? So
Well,
much?
it's not that I didn't hear about the case. I just didn't follow it.
Oh, okay.
I didn't follow it. I didn't know much about it. In fact, when you first mentioned it, I said, isn't this the woman that backed into her husband?
Yeah, see,
I didn't really know much about it.
That's what everybody, isn't this the lady that backed into her boyfriend? Yeah, she killed her boyfriend, didn't she?
And then when we had that question and answer session where I was trying to get educated on what was going on, I realized that, oh my God, this is just a figment of somebody's imagination. I mean, you have a biased cop, a biased trooper, who's actually not by his behavior, but by his own words, calling her names, saying she's a whack job.
She has no ass.
She has no, just derogatory.
I don't know what that means, but
just derogatory. She's a whack job. I hope she kills herself. All of those things, to me, I would have, as a prosecutor, that I would definitely know there's bias there, right?
And don't forget the ATF agent who, when he was given an order not to dispose of his phone, he took the SIM card out of the phone, then disposed of them on a military base down on Cape Cod.
And he admits that
you're supposed to take phones to the burn pit.
He admits that. And people in the comments, I remember, were saying, no, he didn't do that.
Yes, he did.
Yeah, I know.
He admitted it openly on the stand. That he had received and I replayed that he had received the non-disposal order, and then the next day he went out and disposed of it.
So you have a biased cop that's calling her all kinds of names. You have another guy, law enforcement, that threw away his phone after he was told not to. You have them getting evidence in solo paper cups. What else? Mr. O'Keefe had looked like bite marks, scratches or bite marks on his arm,
and they were not caused by a car. The
car would have caused those injuries.
No.
How so?
No.
How?
And then no, there's no way. I think even a stupid person would know that those injuries on his arm were not caused by a taillight.
They would be better off saying They would be better off saying he was hit and then an animal came and bit him.
And then we get to the trial where we have backwards evidence. Remember the car in the Sally port? Oops, we put it backwards again. Oops.
And he didn't hesitate when Alan Jackson asked him.
Yeah.
You didn't mention that when Mr. Lally asked you that question, when he was questioning you. He said, "No, I didn't." Yeah. It would be like, if he really didn't know or didn't think about it, he would be like, well, I didn't think about it. Or
so I guess the next question is, what is trial 2 going to look like? Because whether you like him or not, Adam Lally made some decent points in his brief. As you pointed out, he wasn't very forceful in the way he made the argument, but he made some good points in his brief that there is no verdict. A verdict is only something that's done in court, and that didn't happen here. So my guess is the Supreme Judicial Court is going to say, no verdict. Sorry, you can't say that she was acquitted on 2 counts when there was no verdict. So I'm just.
It wasn't on the record. It's too bad that these jurors didn't have enough time to think about it before they got on the bus, and then maybe go to the judge, and then that way it could be on the record.
So what's trial 2 going to look like when we have, Proctor, the lead investigator, now suspended without pay?
Well, I think it's going to be a bloodbath because I think that if Alan Jackson is back on and Yannetti, they're going to cross-examine those law enforcement that are in big trouble, and that should be admissible.
Of course it will be. Absolutely. We had this conversation before, and I think you agreed with me that that's absolutely impeachment material. So
absolutely. And so what I think is going to happen with with the prosecution, I think the prosecution is going to do one of two things. They're either going to shorten their witness list, or they're going to make it even larger than it was.
Oh my God. How can they?
No more.
There were 74 witnesses over a period of 2 months.
But they seem like the type that that they think more is better. They think that they need more to contradict the bad. They need more because there's so much bad evidence. They need more good evidence so that the bad evidence gets lost in the middle.
Well, I don't know.
I have to say,
I followed the trial as closely as I could. I watched as much as I could, either during the day or you'd go home and you could watch it on YouTube. It was posted on YouTube. So if I missed a witness because I had clients or hearings or whatever, I went home that night and I watched it. So my point being, where the trial started in late April, early May, and didn't conclude until days before the 4th of July, I did not remember what was going on in the beginning of the trial. And I went back through my newspaper articles, which a juror can't do that, but I had my newspaper articles. And since I'd watched, I knew what was emphasized in the papers that shouldn't have been and what wasn't emphasized that should have been. But I had this phenomenon where, really? They said that in the first week of the trial? Really? So, I mean,
it happens. And even in the Idaho 4 case, like, I've forgotten some things and I'm like, oh my God, I forgot about that.
Yeah, I keep some notes. I have a notebook and I keep some notes, and I have to keep going back and I say, oh, really? That's right. Those were the 10 red flags. We did a short this week of 5 red flags in the Koberger case. But to do the short, I had to go back in my notes and look at the 10 red flags episode that I did. And I said, oh, really? Oh, I forgot that. So, if you're a juror and you're allowed to keep notes, I don't know about you, Yoli. I'm a terrible note taker. When I was in law school,
I usually keep things in my brain, but as I get older, it's harder to do. But I usually keep notes in my brain. And I do tend to remember certain things about cases, but it's almost like when you're going to do a trial and then you start reading the depositions and you're like, oh my God, he said that?
Yeah, I have the same experience.
Like, holy cow.
Well, that's a whole different phenomenon. When you're taking a deposition, often you're not supposed to do this, but at least I fall victim to this. I often will be thinking really hard about my next question to the point where I'm not really listening to what the opponent is saying. And I know that's terrible. And if there's any lawyers in the audience, you can excoriate me and tell me what a rotten person I am for doing that.
But it happens sometimes.
I tend to be thinking about the next question. What am I going to be asking this liar? I mean, the deponent. And so I'll forget. So I had the same phenomenon you just mentioned, that when I go back and read the transcript, really, did the deponent say that? Really?
Yeah,
okay.
So I tend to go off. I have an outline, but I'll ask a question and then I'll keep asking follow-up questions and it leads me somewhere else. And then later I don't remember because it wasn't in my outline.
Right.
Like, you know what I mean? And I asked that,
So my only point is that, when you said that maybe the Commonwealth will have more witnesses, I'm like, really? Don't you think they ought to pare them down? And I've been watching some of the commentary that I see in the Boston media, and nearly all the legal experts are saying they need to pare it down. There was too much. Do they really need to get into those texts between the ATF agent and Karen?
Oh my God!
I think you're hot. The feeling is mutual. Come on.
What was that for?
Come on, give me a break.
And then the whole Aruba incident.
Oh yeah, the 2 girls. Yeah, the 2 girls in Aruba.
Well, see, now they have more information since this trial came about.
Yeah.
So I wouldn't be surprised if they start picking up some bad things that Karen might have, or perceived things that Karen might have done, and try to paint her, poorly. But
Well, let's do it the old-fashioned way. There's 3 charges, right? Let's take the 3 charges. Let's figure out what the elements are of each charge. Find a witness to fill in the bucket. Did you do the little bucket analogy in law school? These are
No.
buckets. Yeah, each crime has so many elements. Each element is a bucket. Let's take enough evidence to fill each bucket. Then you've got a case. You don't need to talk about did John kiss a girl in Aruba?
That's motive. I mean, they were trying to establish motive, which is really not necessary, but they were trying to establish motive, and they were doing it in a way that was also making her look like a crazy, when she's screaming. One of the ladies that testified said that she told her, "Get out of here," or yelled at her or something.
You know what else was interminable to me was the afternoon they played the video of her. I forget now whether it was in McCarthy's or the Waterfall, where she had X number of drinks, and they showed each drink. And the investigator said, and they brought another drink over in a cylindrical glass. It's
Cylindrical.
Like, what's the significance? I mean,
Cylindrical glass.
It's a cylindrical glass. So what? So what? It was, but he really made a point of describing them as cylindrical each time. And my question was, did they ever actually submit the receipt for all those drinks in that bar? I don't think they did. I don't think they did. And wouldn't that have been, quote unquote, the best evidence? Wouldn't the best evidence have been an actual receipt showing that she had X number of vodka tonics? Because
water.
It could have been water. Now, we both know you go into a bar and you have a lime in a cylindrical glass. It's going to tend to be a gin and tonic, a vodka tonic. I don't know. But, in the legal business, we shouldn't assume anything. And it would seem to me that the best evidence would have been the receipt. And in this electronic era, receipts are there. Receipts are around. Receipts.
Yeah,
it's a business record.
Yeah.
Anyhow, all right. So I don't know. I think we've beat a dead horse here.
I think it's I mean, they need to pare it down for sure. If they're going to go again, they need to pare it down. But my thinking is just because this case is so absurd that they want to bury the bad evidence with, they want to bury the bad evidence. So they're putting a whole bunch of stuff on top of the bad evidence so that you forget, or you see the, importance of it. And, it's important to argue that, when you have a cop or law enforcement that is biased, that is calling you a wacko, they already think you're wacko. I mean, Proctor thinks she's a wacko. And so what do wackos do? They back into people and
run over their boyfriends. I mean, me, the wacko.
And there was never any evidence that she backed into him. There was never one whit of evidence. I think the case should have been dismissed. The Commonwealth's own witness, who was their accident report guy, they claimed he was an expert, but he was not an expert. He was an accident report guy. He said that the evidence was consistent with a side swipe.
That's not beyond a reasonable doubt.
It's not beyond a reasonable doubt, and it's also a side swipe is not a back in to you with the light. So, I mean, it's just their own evidence was shoddy.
And so the side swipe caused all those bites on his arm.
No, that was a dog, and even a stupid person knows that those were caused by
come on. How did the car? Oh, it was the shards from the glass that didn't break.
No.
Yeah.
Yeah. Right. Sure. So, I don't know. It just, I hate, again, I said it in our live, and I'll say it again. I really don't like to disparage another member of the Massachusetts bar because it's a relatively small bar. We all cross paths with each other. I did a deposition with Michael Morrissey many, 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 many years ago. So it's a small bar. You never know when you're going to be running into people. So, but they need a different prosecutor. There, I said it. They need They need a guy that can deliver a punch, like Creighton Waters, the guy that prosecuted Murdoch. There was a guy, and he had a whole team of people. He had a whole bunch of other people with him. But when he got up on the stand, you dropped everything. You made the clients wait out in the waiting room because you knew he was going to punch Murdoch right in the nose. And that's what you need. You know, I'm sorry.
Well, yeah, and yeah, it's one of these things where it's hard because it's a high profile case, and I know that I can be critical sometimes of people, you know, and of judges and lawyers, but I have handled high profile cases, so I know, and I know that it's hard, and you don't always do what you normally do because you know lots of people are watching.
Yeah.
And
it's a tough job. Trying a case is tough. People watch this stuff on YouTube now and TV, and I've heard some YouTubers, there's one guy particularly, he'll switch around from, I don't even remember his name, but he'll switch from one court to the other court to the other court.
Is that the recovery?
I'm not going to mention any names, but I've heard people make snarky comments about this and that and the other. And it's like, you know, you get up and try a case because is it easy? No. No, it's not easy.
It gets easier as you do them, but it's still not easy.
Yeah.
You know, and then dealing with your client it's preferable to have two people because you can't always fill your client in on what's going on when you're trying to do the case. No. You know, you got to prepare for the next witness, and the client is saying, well, what's going on? What's going to, and you're like, so it's a hard job. And especially if you're in the media, I mean, if I do criticize lawyers that are doing a trial in the media, well, I'm doing it, but I also know that it's hard.
It is hard. It's not easy, you know. So, all right. I think we've beat this dead horse into the ground, but it's a case that we're going to be watching. It's a case that is got a lot of attention nationwide. It's a case that, you know, is going up on appeal. If it doesn't go up on an appeal, I'll eat my hat.
Might have to get you a hat first.
It will.
Yeah.
All right.
Either side. Okay, Yoli, thank you very much for joining us again. I appreciate it. You always give us a lot of good comments and help us kind of understand things that are going on. And folks, let us know how we did. We know this is a controversial case. We always get your comments, but we do read them. We just ask that you be polite, kind, don't personalize it, but feel free to let us know how you feel. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.
And that's that.
And you wackos don't drive over your boyfriends. You got it? I'm watching
Whack
you.
jobs.
Whack jobs.
Oh
Why
my
would he say that? Why would a professional investigator who's texting to others, knowing that texts are fully recoverable, why would he say that and all the other things?
It's just all those CTs. They just see their boyfriends cheating, and the first thing they do is run them over like weeks
that's
after.
it. And then they cut them up. They cut them. or they bite them.
You guys,
It's like me before running over my boyfriend.
you guys tell me how out of line I am. I'm the guy, 2 women. So you guys tell me how out of line I am. One of my favorite pictures, there's a lot of photographers down there taking a lot of pictures of things going on outside the courtroom. One of my favorite pictures is a picture of a woman holding a big protest sign that says, "Proud to have no ass."
I saw that.
Slay.
I mean, that is just, what does that have to do with anything?
No.
What does that have to do with the committing of the crime?
Well, everybody knows that the curvier you are, the less likely you are to commit a crime.
The guy
Probably.
the guy said much worse, which we're not going to go into now. We did go into, I think it was the first week our poor intern Red was here. The first week our poor new intern Red, who's not with us this week because she had a seminar to go to.
And Lady wasn't here. It was just me, you, and Red.
And Red is a high school student. She's just a little high school student. And I asked her, I said, there's going to be some kind of rough language in here. You might not want to, help us with this one. Would your parents, or what about your advisor? Her advisor is taking a very active role in supervising this internship. I've never seen such a thing. But anyhow, I said, are they going to have a problem? Oh, no, it's fine. And so we're talking about all these horrible, disgusting, awful things that Proctor said, which really, should never have been said in the first place. But anyhow, so I was like kind of cringing. She was just like, heard it.
Classic Massachusetts.
Heard it all.
Nothing bothers her.
Oh my goodness.
All right.
Very relevant to crime.
Yoli, have a good one. Keep on cranking out the episodes. You going to do another episode soon?
I will. Yeah, probably this weekend. On what?
Yeah, what are you going to do it on? Or should we just wait and be surprised?
Well, I was thinking of doing it on this case in California about a missing woman. And she was in an abusive relationship. And the boyfriend or husband has ties to a casino on tribal land.
Oh.
And the tribal people, there's some tribal law involved. And it's kind of an interesting case. I know some other creators have done segments on it.
Okay.
But it's interesting. Beautiful woman.
Sad.
Tiny. And her sisters have spoken out. So I just wanted to, maybe I might do something on that about the tribal law and how hard it is to get search warrants for that, or go in and get cooperation,
Yeah, interesting.
Because there is an attorney from my office has a case, a kind of a slip and fall kind of case in a casino, and he's going through this tribal law thing, and the rules are just so weird. It's like they can get away with it. Like what? Like some of what?
I didn't think a non-tribal attorney was even allowed to practice because
you can get admitted.
There's a couple of casinos not that far from my Massachusetts office, and I've been called by people that had a slip and fall or whatever, a motor vehicle accident down there. And I've been told, I did my research the first couple of times people came to me with these cases. I've been told under no uncertain terms could I handle those cases.
It depends on the tribe. So,
Really?
Yeah. So in this part, it's the San Manuel. Well, I probably shouldn't say it, but in this case, it's a casino in the San Bernardino County, and you can apply to practice in the tribal law. I mean, to practice tribal law, you can apply. And so he applied, and I mean, he's always taking these crazy cases, but he applied and he got admitted to practice. So he's now practicing tribal law, and it's just hard. So over here in California with this missing persons case, I thought about doing a segment on that, because some of the issues that you run across when you have a tribal land is interesting to me anyway. I don't know if it'll be interesting.
Yeah. Well, he's a better man than me, because I didn't know you could even do that. But
maybe in some tribal lands you can't. Like they have their own rules. They set their own rules.
Yes.
And if they don't want you to practice in their tribal court, they can set their own rules. That's what's so crazy about it, is that they do. And in this particular case, an outsider can apply, and they vet you, and then they let you come in.
You know what? I've already taken 2 bar exams. That's enough.
Yeah,
That's enough for me. I don't need any more. Plus, between the state and the federal, and I forgot. You have to go through the process for the state side, then the federal side, then the bankruptcy side. And I went to file something, and I had let one of them lapse, and I didn't pay my dues. They're like,
geez.
So I can't even keep up with the ones I have. I fixed the problem immediately. And the court clerk was very helpful. She was like, I hate to tell you this, but you're not admitted in this particular court anymore. I'm like, what? She helped. She was very, instead of like in the old days, the court clerks would have scolded you. She's like, here, go in here. Just give us your credit card. We'll get you back up and running like immediately. No waiting. I probably should have told that story on YouTube Live. People are going, what kind? And we get these come, what kind of an attorney are you?
It's okay. I need to renew my hair license. It happens to all of us.
Well, I think they can make it really difficult for you. They can make you go back and jump all through kinds of hoops. And in the old days,
look at Idaho. I looked at Idaho to be admitted in Idaho.
Yeah.
And you don't have to take the bar if you've been an attorney for 10 years or more. So I don't have to take. You wouldn't have to take the bar.
Get on that case, Andrew.
Yeah, there you go. Yeah, it's been a few more than 10 years for me. All right. Lally, thank you so much for being with us. You always contribute so much and help us. So have a great weekend.
Okay.
Yeah, we look forward to watching your video. Thank you so much.
Okay.
I might do it on that. I'm not sure yet, but
It sounds like a good one.
Yeah. Okay.
Oh.
Bye.
All right. Bye.
Bye. Thank you.
Mm-hmm.